Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about sexual assault and recantation. Cases that should have gone to the Supreme Court of Canada, but didn't. James Everard was accused of sexual assault by a teenage complainant. At trial, one of the major issues was the credibility of the complainant, because apparently, prior to the trial, she had told a teenage friend of hers that she had made the whole story up. This was obviously a significant issue for Mr. Everard, who was facing grave consequences if he was convicted. The trial judge rejected the out-of-court recantation based on assumptions about how a teenager would react if they were told that somebody had made up that story. Mr. Everard appealed, unsuccessfully, and sought leave to appeal to the Supreme Court of Canada, arguing that trial judges can't just make up reasons why, based on common sense, that somebody would recant their story of sexual assault and how another individual would react to that in determining whether or not that conversation took place. This case obviously raises important issues as we see more and more sexual assault cases finally being prosecuted on the strength of the Me Too movement and the understanding that we should believe the stories of survivors. It becomes all the more important to equip the courts with guidance and the tools necessary to assess what happens in circumstances of allegations of recantation or in circumstances of actual or purported recantation, and how trial judges are supposed to assess those, in order to protect both people accused of sexual assault and people who are making the accusation and ensure that justice is done in these cases. We need guidance from the Supreme Court of Canada about how these cases are supposed to be decided, and having some direction about what happens when you have witnesses testifying about people recanting stories that's contradicted by other witnesses is not just a matter anymore of simple credibility assessment left to the trial judge. In this case, it's much more significant and much more serious, an issue that affects a large number of people and necessitates intervention by the Supreme Court of Canada. I think the Supreme Court of Canada really missed an opportunity here to make sexual assault cases more fair for all of the people involved, and to ensure that justice truly is going to be done in these cases, so that we don't hear concerns about people being acquitted who shouldn't be, or people being convicted who shouldn't be. Unfortunately, it's going to take another case, another recantation, another story, and another sexual assault trial for this to make it all the way to the Supreme Court of Canada again. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, share with your friends, and thank you to Brazen Bull Creative for putting together these videos.